So we're back with the second portion of the Chapter 5 video. We are talking about the four primary sources of law. We are just now getting started with constitutional law. Constitutional law is the law that is found in our federal constitution and in the constitutions of each of the states. And also DC, the District of Columbia. So there are actually 52 constitutions in the United States. The federal constitution is often referred to as the supreme law of the land. Okay, it is the head of our system of our legal system, and if anything contradicts that federal constitution, then that is when we need the courts to step in and to review what has transpired and determine whether or not something is constitutional or unconstitutional. The U.S. Constitution, a lot of these things that I'm going to talk about you learned in your government civics course, which might have been a long time ago, so we'll just refresh. The U.S. Constitution establishes the three branches of federal government: the executive, the legislative, and the judicial. Okay, it can be amended. It is amendable, and that's where we get the Bill of Rights, the first 10 amendments to the Constitution. And an interesting piece of information or history, and you can go back, I think it's in the crash course on U.S. history, but when the Founding Fathers basically overthrew the government and the Articles of Confederation, they created the Constitution, but they did not create the Bill of Rights. They had been there in Philadelphia for so long. It was hot. They were ready to be at home. And so they decided not to draft a Bill of Rights and argue over what was going to be in it. And they decided to let that proceed as amendments to the Constitution. So the Constitution of the United States creates the branches of government. It divides power between the federal and the state governments. We'll talk a little bit more about that in a second. And it protects and ensures our individual rights. Federalism, that is the process of, or the concept of sharing power between the federal and the state governments. Okay, there are powers that are specifically enumerated and laid out in the Constitution that authorize the federal government to do certain things. But if it's not there in the Constitution, then that is power that was reserved for the states. Our system was made up or based on the concept of separation of power. You have to remember that these men, and of course they were all men, when they came together to overthrow the Articles of Confederation and create the Constitution, they were scared. They were scared of themselves. They did not want to be ruled under tyranny. They had just fought to get out from under the king's tyranny, the king's authority. So they were very much about preserving these rights, individual and states' rights, and they were legitimately afraid of a central government. So they had to spend a lot of discussion about how they could protect that. And one of those ways was through the separation of powers. The first three articles of the Constitution set out the responsibilities of the three branches of government. And there is a system of checks and balances that prevents any single branch from becoming too powerful. That's what they wanted to achieve. Sometimes that means that we spin our wheels. It takes us a long time to get something accomplished. But the reason for that is to keep every branch in check. The Constitution also has the Supremacy Clause. It says that that the Constitution and the federal statutes and regulations are the supreme law. Okay, and it also is set out so that Congress expressly provides for exclusive legislative activity on specific topics or specific areas. The Commerce Clause grants Congress the authority to regulate commerce among the states and foreign nations. We also have, it allows states the ability to regulate intrastate commerce. So anything that happens within the borders of the state. And then there's the Dormant Commerce Clause. It's an area of interstate commerce that is not currently regulated by Congress, but state regulation can't unduly burden the interstate commerce. So things, it allows for the federal government to step in areas of commerce if things become too burdensome based on state regulations. Federal Constitution, keep saying it, highest law of the nation, has the Supremacy Clause. Our constitutional rights are found in the Bill of Rights. So the Bill of Rights, the First Amendment is the one that we hang our hats on as a country. Protected speech is one of the biggest pieces of the First Amendment. But keep in mind that there are limits on speech. There is fully protected speech, meaning there is speech that there's no prohibition or regulation about it or can be created about it. There's limited protected speech. There's some restriction with regard to time, place, and the manner of the delivery, but not to the content. And then there's unprotected speech. There are some types of speech that can be totally forbidden. Things like yelling fire in a crowded movie theater. Then there's obscene speech, and the Supreme Court has set up a test to deal with that, saying that the work as a whole appeals to the prurient, it's a hard word, interest when you apply contemporary community standards. It depicts or describes sexual conduct that is patently offensive, and work also lacks serious, and here's the key to determining whether or not something is obscene is, does it lack serious literary, artistic, political, or scientific value? While I would love to spend more time on constitutional law, but we still have a lot to cover, and I recommend taking constitutional law as an elective. The problem is it's not offered every semester, but we can't stay on this too long. We have to move forward. Speech in cyberspace, which is something that we have been and will continue to be dealing with. It's a probably relatively new area compared to other types of speech. The Communication Decency Act allows for the regulation of speech on the internet. The real purpose is to protect those underage from exposure to sexual content on the internet. There's case law that provides a further definition of the statute and guarantees the highest level of protection to the internet. Next, we have the Due Process Clause. It's actually addressed in two amendments, the 5th and the 14th. It prohibits the government from taking life, liberty, or property without the due process of law. Substantive due process means it limits the content, the scope of statutes, ordinances, and regulations. Procedural due process requires that you must have a proper notice, proper hearing before you can be deprived of life, liberty, or property. Not to say that you can't be, but that you have to be given notice and a hearing. Equal protections also in the 14th Amendment. State, local, and federal government cannot deny equal protection of the law, meaning if person A should be treated and protected under the law the same way that person B is. However, there is a levels of scrutiny that a court will go through in order to determine whether or not the law has been applied equally. There's strict scrutiny for prohibiting activity or regulation based on, let's just be based, not basis, on a suspect classification and an fundamental right. So whatever it is, whatever the law is doing, it is affecting either a suspect class or a fundamental right. Intermediate scrutiny means that it's affecting a protected class, and if it has a reasonable relationship to legitimate government purpose, then it will be allowed. And then everything else falls under the rational basis test. If there's a justifiable reason for the law, then it will be upheld. So state constitutions. Each state has their own. It's going to address the organization of the state government, what the state government's powers and limitations are. As I said, the 10th Amendment to the U.S. Constitution reserves all powers that are not specifically granted to the federal government in the Constitution to the state governments. So state constitutions are the supreme law within the state borders unless it conflicts with the U.S. Constitution. So the next source of law we're going to look at is statutory law. First, federal. Federal statutes are the laws that have been enacted by the United States legislature, the U.S. Congress. They are given constitutional authority to draft those statutes, to enact those laws. And states, statutory law in the states is organized pretty much the same way. If there's a conflict between federal law and state law, federal law is going to rule. When we also are talking about statutory law on a local level, we're talking about local city and county ordinances. I'm not going to walk through the process of how a statute is passed. You should be covering that in your research and writing 1 course, but suffice it to say that the state process is very similar to the federal process with regard to drafting, debating, passing statutes. Statutes get published. You know, I said earlier that cases are published in reporters. Statutes are published in a statute at large, which is not necessarily user-friendly. So they are then passed in what are called codes. We codify the law. Statutes, when they are in a statutes at large format, they are published chronologically. So unless you know the day that a legislature passed a particular law, it would be very difficult to find it. By grouping them by topic, which is called codification, we create a code where it's more easy, you can more easily find statutes based on the topic that they are codified under. That's why our statutes are in the official code of Georgia annotated. That's where our statutes are codified. As I said, you'll discuss more of this in your legal research and writing 1 course. There are also what are known as uniform laws. The National Conference of Commissioners on Uniform State Laws are a group of legal scholars who work on trying to lobby legislatures, to have a uniform law about a particular area, whether it's probate or family law, and they draft and propose these uniform laws to the state legislatures. And usually what happens is even if they vote to pass those uniform laws, they end up adapting them to suit their needs. And so we're back to having 50 different interpretations or applications of what burglary means in 50 different states instead of a uniform law. The next source of law is administrative law. Now, some people or some scholars and some texts that you read will discuss that administrative rules and regs are the 4th branch of government. That's in quotations. Why? Because it is a very important source of law. Administrative rules and regs have the same weight as a statute. Okay? Administrative agencies are created out of a constitutional clause that allows them to oversee a specific function of government. They are at the federal level, they're at the state level, they're at your local level. Agencies are created through the enabling legislation that Congress passes or the state legislature passes, creating the agency, saying what its purpose is, giving it the power to govern a certain slice of pie, let's say. And what's interesting about administrative law is that most administrative agencies have a mini government unto themselves. They have a a rule making, a rule enforcing, a judicial piece within their agency. Um, the Administrative Procedure Act of 1946 states that, it was passed and states that an agency has to give the public notice when they enact certain rules and regulations. They have to allow time for interested parties to comment, and then the final rule gets published in the Federal Register. And I had a lot of experience with this in my, I call my former life, when I worked as in-house counsel for a hospital consulting firm. We worked very closely with the rules and regs of the Social Security and the Centers for Medicare and Medicaid, and a lot of those rules and regs would come out each year in July. The initial proposal, people would have time to read them, to offer input, and then they would be published and go into effect on October 1st each year. And so I had a lot of experience working with this particular process. They also have an investigation and enforcement piece to administrative agencies. They can request documents, specific files from individuals and from organizations. They can do on-site inspections. They can do searches. They have the power to do all of that within their agency. Then they have an adjudication piece. They have administrative law judges that that hold hearings addressing issues with the enforcement of those rules and regulations.